Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. Today I want to talk to you about international inheritance laws and what U.S. residents need to know. Now, estate planning can be complicated enough when all of your assets, your accounts, and property and loved ones are located within one country. But for U.S. residents with international connections, whether through property, citizenship, residency, business interest, or loved ones living abroad, it can become significantly more complex. Now, different countries have different rules about who inherits, how much they inherit, and the taxes and the formalities involved. Do not assume that a US based estate plan will cover your overseas assets. Extra planning steps are often required at home and abroad to harmonize your plan across borders and avoid any unexpected inheritance or tax issues. So let's talk about when foreign inheritance laws can affect you. A U.S. resident's estate can be affected by foreign inheritance laws when they own real estate or investments abroad. Foreign inheritance laws may also apply if you meet some of the following criteria. If you own assets including tangible property such as a vehicle, artwork, or other personal effects located outside the U.S., or if you hold dual citizenship or maintain foreign residency, or if you have heirs, spouses, or business partners living in another country. Or perhaps you own business interests or cross-border financial accounts, such as bank accounts, brokerage accounts, or stocks in a foreign jurisdiction. Failing to account for foreign inheritance laws can result in your assets passing to unintended heirs, unexpected tax consequences, and complex probate proceedings that span multiple countries. Proper cross-border estate planning, ideally with an attorney familiar with both U.S. and foreign laws, is essential. In many cases, collaboration with a local attorney in the country where your assets or loved ones are located will also be necessary to ensure that your wishes are honored. Now, when planning an estate that spans multiple countries, it's important to understand how different types of assets are treated. This tangible property, so real estate, vehicles, personal effects, and other physical assets, are often subject to local probate or inheritance laws in the country where they are located. So let's talk about real property is typically governed by the laws of the country in which it is located, regardless of where the owner actually resides. Now, when it comes to financial and intangible assets, the treatment and reporting requirements for bank accounts, stocks, bonds, retirement accounts, and other non-physical assets vary widely by jurisdiction, depending on where the asset is held, where the owner resides, and their citizenship. Now, when it comes to estate planning, knowing which laws apply is not just a technical detail. For many reasons, it is a foundation of getting your plan right. Now, if there's family or assets in multiple countries, if you have heirs or beneficiaries that live abroad, the way they inherit may differ significantly from what you expect. And sometimes there's a conflict of laws. A key challenge in cross-border estate planning is determining which country's laws applies. The country of your nationality, your residence, or where the asset is located. Getting this wrong can lead to unintended results. For example, in Spain, expats can choose their nationality's law via EU regulation, but only if done right. If additional steps are not taken, Spanish forced heirship kicks in. Now, ignoring regional variations or failing to comply with formal will requirements could mean that your wishes are not legally enforceable. Which law governs matters. Real estate is governed by the law of where the property is actually located, while intangible assets like stocks may be governed by where the company is incorporated. Now, there's the issue of the validity of estate planning documents. A U.S.-based will or trust may not be recognized or could be overridden by foreign law. Administering an estate abroad often involves complex and time-consuming procedures, such as obtaining local death certificates, registering property, providing certified translations, and meeting notarial or authentication requirements. These steps can be costly, slow, and prone to misunderstanding. In some cases, heirs may discover too late that the will or trust created in the U.S. does not effectively control assets located overseas. Now, there's different rules on testamentary freedom. Now, common law countries like the U.S. and UK generally allow greater flexibility in distributing property. But many civil law countries, France, Germany, Spain, Dominican Republic, and Thailand, impose forced heirship rules that mandate a share for children, spouses, or other family members. U.S. residents used to testamentary freedom can run into limits abroad. Now let's talk about your peace of mind. Ultimately, people want certainty that their wishes will be respected and their loved ones will not be left with a legal mess. Even if your loved ones ultimately inherit, multinational probate can be slow and expensive if it's not planned for in advance. Inheritance laws vary widely across countries. The following country by country comparison highlights popular destinations and illustrates differences in inheritance laws. So in the UK, they're English speaking, they follow common law, and it's very popular with retirees and people who want to purchase second homes. Their legal system or inheritance law is based on common law. In their forced heirship or testamentary freedom. In England and Wales, there's no forced heirship. People can leave their money and property to whomever they choose under their last will and testament. Joint ownership and beneficiary nominations are also available for passing on accounts and property. However, dependents can challenge the last will and testament. If someone dies without a will, the inheritance is divided according to statute, which is based on the overall value of the deceased person's estate. So let's talk about Portugal, Southern European retirement hotspot, known for scenic coastal properties and favorable climate. They use a civil law system. Portugal has forced heirship rules for children and spouses, and in some cases, parents if there are no children. The legitima, a reserved portion of the estate, must go to these heirs, while the remaining disposable portion may be freely distributed according to the decedent's wishes. Now let's talk about the United Arab Emirates. They represent the Middle East with residency by investment options. Their legal system depends on the religion and the nationality of the person. Muslims follow Sharia, Islamic inheritance law, while non-Muslims generally follow civil law principles. Now, for forced heirship on Sharia law, certain heirs, for example, children and spouses, are guaranteed fixed shares of the estate, and male relatives often receive larger portions than female relatives. The spouse may not automatically inherit the entire estate, and other family members may be entitled to a portion. Now, they have civil law and testamentary freedom. Non-Muslims may make a will and distribute their money and property as they see fit. If there is no will, civil law principles generally apply. Typically, half of the inheritance will go to the surviving spouse, and the other half is divided equally amongst children. If there are no children, the parents may inherit instead. Expatriates can request that their will be governed by the inheritance law of their home country if the will is properly registered in the United Arab Emirates. So let's talk about Panama. Central American destination popular with retirees due to favorable cost of living and retiree benefits. They use a civil law legal system. Now, Panama generally allows for full testamentary freedom, allowing flexibility in distributing property and financial assets. If there is no will, children of the decedent and their descendants receive their inheritance in equal parts. If there are no descendants, the deceased ancestors will inherit. A surviving spouse inherits equally with each of the previously mentioned classes. So let's talk about the Dominican Republic. It's a Caribbean retirement and vacation hotspot for U.S. buyers. They also have a civil law with forced heirship rules. In the Dominican Republic, there are statutorily required shares for children and spouses. The remaining property can be freely allocated. If the deceased leaves children, 2/3 of the estate must be reserved and divided amongst them. If there is a surviving spouse, they are entitled to 1/2. Now in Thailand, which is a popular Southeast Asian destination, has a tropical climate and a lower cost of living. In Thailand, they use a civil law with restrictions on who can own Thai land. Now in Thailand, you are free to create a will and dictate who will receive an inheritance from you. However, there are some restrictions regarding the ownership of real property. Absent a will, Thai law dictates who will inherit. The order of priority is decedents, children or grandchildren, parents, full-blood siblings, half-blood siblings, grandparents, and aunts and uncles. The share a surviving spouse receives will depend on what other heirs are actually living at that time. If you own property in other countries, you're going to work with an attorney at home and abroad. Coordinating an estate across multiple countries can add complexity to your plans, but working with a foreign attorney who understands the local legal system and administration requirements can help make your plan more manageable and effective. Your U.S.-based attorney can help identify qualified foreign counsel and ensure compliance with both U.S. and foreign laws. Here are some key considerations when you're hiring a foreign attorney. First of all, you want to make sure they're an expert in that jurisdiction. Familiarity with local inheritance and property laws for both tangible and financial assets is a must. You want to make sure that there's clear communication in a language that you understand and proper translation of wills and contracts. You also want to address potential taxes on the estate for owners and beneficiaries. Now, collaboration between U.S. and foreign counsel to ensure that wills, trust, or estate documents are effective in each jurisdiction. Now, careful planning and coordination with an experienced counsel in both countries can set the foundation for an estate plan that respects your wishes while protecting your loved ones, no matter where in the world your assets are located. If you find yourself with assets or loved ones abroad and need an estate plan that addresses your unique situation, give us a call and we'll be able to connect you with somebody that can help you. So I want to thank you for watching. I'm Attorney Kelly Longtin from Kelly Longtin Law, and thank you for watching our YouTube channel. Till next time, I hope you all have a great rest of your day.